All right, we're rolling. Michael Ware with the Iowa Firearms Coalition. Glad to see everybody back. We have a special guest today. I want to introduce Sean Brady. Say hello.
Hello.
I'm glad you're here. I'm glad you're here. I don't know if very many people know you. I felt terrible. I must apologize right up front. When my buddy Dave put us in contact, he's like, "You know him." I'm like, "No, I don't." He said, "Yes, you do." And I'm like, "No, I don't." And then he started rattling off all these cases. And I'm like, "Yes, I know him." I said, "I don't know him, but I know of him." So it's a pleasure to talk. Thank you for coming on today. Now, you do what for a living?
Sure. I'm an attorney. And first off, thanks for having me. The pleasure's all mine, Michael, as you know. I enjoy talking about this stuff. I enjoy doing it to a certain extent. I wish I didn't have to do this, to be frank. But what I do is I'm an attorney out of California. And because, people might say, oh, well, what's a California attorney doing here talking to the Iowa Firearms Coalition? And the reality is the gun control legislation that we're seeing sort of proliferate throughout the country, oftentimes, if not almost exclusively, begins in California and spreads outwards. And one of the reasons I believe you wanted to chat with me is a recent law in Illinois that was passed and that I was a part of. The lawsuit challenging is a prime example of that. They essentially copied and pasted California's so-called assault weapon ban. And I hope folks will forgive me when I say the word assault weapon. It's not my chosen vocabulary, okay? The state of California, the state of Illinois, and other states have statutorily defined certain guns as so-called assault weapons. So when I say that term, I'm using their legal jargon that they invented. Yes, admittedly, it's not my term, it's their term. So please don't get mad at me. Don't send me hate mail.
I'm not. I'm not. I often, those things give me heartburn. They cause me to seize up a little bit, or at least they used to. And then there's a part of me that tips my cap to an opponent that propagandizes like that with that kind of success. Although I don't want to do that. I'm not about mind control and manipulation. I can understand their level of success with that. I often wonder if I ran into some of these folks in their official capacities, if I started labeling them assault legislators or assault judges, what they would think of that. And oh golly, well, I'm sorry, but you fit the textbook definition of assaults as far as I'm concerned. So it's okay. We'll give you that. We know what you're talking about. So let us know what's going on next door in Illinois, and specifically why you came to town, because that's what I was interested in primarily. And I want people to understand the significance of what you're fighting against and how it touches them.
Sure. So Illinois passed a law called the PICA, as they refer to it, and it's the Protection of Illinois Communities Act. They always put these cute little names like, how could you possibly be against that, right? Well, as I always tell folks who want to have the gun control debate with me about, oh, why are you against this law or that law? I always say, I'm generally opposed to most gun control, but setting that aside, the devil's always in the details, okay? So when you talk about, what is an assault weapon, right? People say, well, how could you be anti-assault weapon, or how could you be for people having assault weapons? And then we get into a discussion on what exactly is an assault weapon. I mean, Illinois has defined as an assault weapon firearms that are sometimes the quintessential teach your kid how to shoot gun. For example, a Ruger 1022. I'm sure everybody on listening is familiar with the 1022 if they don't own one, right? They either own one or they've shot one or they know somebody who has. In Illinois, if you put an adjustable stock on a 1022, it is an assault weapon. If you have an AR platform rifle that is chambered in 22 LR rimfire guns, 17 HMR, these are assault weapons. And so Illinois has actually gone a step beyond what California did. At least California limited it to centerfire rifles, right? Centerfire firearms. Illinois has declared guns as innocuous and elementary as the Ruger 1022 as an assault weapon. And beyond that, they also, what I think is debatably crazier, I think it is crazier, it's the mere parts of guns can be considered assault weapons. So, for example, the adjustable stock. Let's just say you have the adjustable stock separate and apart, and it could be affixed to an AR platform rifle. That's an assault weapon. So, it is a very ham-fisted attempt at getting to, what they really want to get at, which is AR-15s. But that's not what they did. And don't get me wrong, I'm anti a ban on AR-15s is obviously also, but they swept up so many other firearms in the process of targeting targeting the AR-15, including shotguns. A shotgun is any semi-automatic shotgun that has a pistol grip is an assault weapon. Any semi-automatic shotgun that has a detachable magazine, regardless of capacity, any semi-automatic shotgun with a fixed tube that can accept more than 5 shells. I mean, these are standard everyday guns that people own, and to equate those to so-called assault weapons, and then make the case that they're military grade firearms, which is what we were forced to litigate in Illinois because of the Seventh Circuit's ruling. And I'm happy to explain all that and how we got there. So, and I want to be very clear, just so people don't yell at me when I talk about military versus non-military. We all know that's sort of a false distinction in and of itself. But that's a task the Seventh Circuit handed down to us. So that's why we're doing it.
I don't think that there are a lot of people who say, well, they're ignorant and silly. They don't know what they're doing. And I said, well, I will usually tell them, I'm like, well, there was a time when I tried to give some of these people a pass. Maybe they were well-intentioned, but either they know and they don't care, or they don't know and they don't care. I'm looking at, okay, so if I understand it right, Newsom signed some bill saying, okay, yes, you can vote within the last few days out in California. And so I look at this and I say to myself, okay, we're willing to knowingly game the system to hopefully get an outcome that we'll use to stand on and say, no, this outcome stands because these are the rules. So, and when I explained that to my wife, she's like, I don't understand your logic. And I just said, well, it's like this. It appears as if they're willing to do whatever it is they want to achieve an outcome, everybody's knowing at this, saying, you're cheating. This is wrong. This is inappropriate. It doesn't appear to be lawful in any way, shape, or form. And then when you get the outcome that you're hoping for, you're going to stand there and say, this is lawful. We got to take the results. We got to adhere to this. We've got to accept the outcome. And so the whole time it's based on a big lie. They know it. And they figure, well, the ends justify the means. I've told my friends that 1,000 times, Sean. When you hear somebody say the ends justifies the means, you're hearing the beginning of cruelty, because you're saying, I don't care what we do to get there. I'm willing to rape, murder, and steal whatever else so that I can get the outcome I want. And it's that dastardly.
Absolutely. Victimhood is a strong, medicine. It's something that once somebody sees themselves as a victim, and a righteous victim at that they can do whatever means are necessary to fix the injustice that they perceive. I mean, it's a dangerous ideology to be in that mindset.
Oh, no doubt about it. So, can I ask questions about the case specifically? Who'd you represent? What kind of outcome are you hoping for? What kind of time frame should we be paying attention to? Do we know any of that stuff?
Sure, absolutely. And I'm happy to identify, some of the folks I'm representing in Illinois. I do want to make clear at the outset as I speak that I am here speaking on my own behalf. I don't represent anybody in giving my little spiel here. Okay. These are my own opinions, my own thoughts. I'm happy to explain what I've been doing on behalf of my clients there in Illinois, but I do not speak for them. So, if anybody takes any issue with what I'm saying, don't bother them about it. You can bother me. We represent a group. So to step back, when Illinois passed PICA, that's the shorthand we use for this law. A whole host of pro Second Amendment groups, federal FFLs. I'm sure everybody's familiar with that term. They're licensed gun dealers. in Illinois. Various groups, individuals, businesses lined up to challenge the law, right? Understandably. And so there ended up being essentially 4 different groups of plaintiffs represented by a different counsel. I represent one group. There's 3 other groups of counsel who represent the other 3 groups. But because of that dynamic, the court decided to sort of consolidate the 4 cases just to have it heard as one case so that there wasn't a bunch of repetition, there wasn't inconsistencies. And it ended up working out pretty well. We all sort of coordinated very well together in getting briefing done. We're all on the same page. As far as briefing, we all agreed that we should have brought what's called a preliminary injunction initially. And for those who aren't up to speed on legal jargon, a preliminary injunction is essentially saying, hey, court, we think that you should order the state to not enforce this law while we litigate whether the law is legal. And there's a standard to get that. It's essentially the plaintiffs, the people who move to preliminarily enjoin a statute have to show that they're likely to succeed. So you can't just file this motion and you have no chance of winning. The court's not going to grant it. You have to show I have a very strong case. I'm likely to succeed eventually. And, there will be irreparable harm if we don't. So we made that case to the court, and the court agreed with us and granted a preliminary injunction on the enforcement of PICA before it took effect. And the argument was, look, you're going to ban, it's not just, so-called assault weapons that they were banning. It was also so-called large capacity magazines. And that was any magazine over 10 rounds for a rifle and any magazine over 15 rounds for a pistol. Of course, you and I both know which one is for a rifle, which one's for a pistol. They don't know. They then try to change the law to say, or not change the law, but say, oh, it's whatever the person intends to use it for. Okay. So that means that the same magazine is legal if it's going to be used in a pistol, but not in a rifle, even though they're interchangeable. Anyway, so I digress. I could go, if I go off down rabbit holes on how crazy the law is, please put me back on track.
You're okay. We get it. Go. All right.
Yeah. So, we brought the preliminary injunction saying, look, you're going to be depriving people of their access to these things. And the law actually allowed for people to maintain possession of their items as long as they registered them by a certain date. And our position was, well, that's insufficient. People shouldn't have to register their items with the government. My particular clients have a separate challenge to the registration requirement, separate from the law restricting the sale of, or I guess the sale or acquisition of these items. So we convinced the court, we're likely to succeed. You should stop this law from taking effect on its deadline. The court issued an order in our favor, and the state of Illinois, of course, appealed that to the 7th Circuit Court of Appeals. And there, the 7th Circuit not only stayed the lower court's order preliminarily enjoining the law, which means that it's no longer preliminarily enjoined. It's essentially the 7th Circuit automatically took away our win as soon as we got there, but then affirmed that win or that takeaway of our win by issuing an opinion saying that the trial court was wrong in issuing it in the first place, and that the 7th Circuit set out a standard that is, I'm going to be judicious in my description of what I think of it, but I'll just put it this way. The Supreme Court precedent makes fairly clear that arms are automatically protected, right? You say I have an arm, then you're automatically within the Second Amendment framework, right? And then you have to apply the test that that the Supreme Court set down. Okay, we're in the Second Amendment zone. Now, is the state's regulation of that arm justifiable? So I gave you an example, hand grenades. People would say, well, how could you say hand grenades are protected by the Second Amendment? Well, they're arms, so they're automatically in the framework. Now, I think a plaintiff challenging a restriction on hand grenades would have a hard time prevailing ultimately, because most people don't have hand grenades, right? So they're not common items that people keep for self-defense, right? There's an argument that they're inherently dangerous because they can just go boom and blow, right? So, but you see, that's the analysis that needs to be undertaken. That you don't just say out of the gate that hand grenades have no Second Amendment protection. You have to go through the steps, and that's pretty clear. At least that's my reading of Supreme Court precedent. But what the Seventh Circuit did was say not only are arms automatically subject to Second Amendment scrutiny, but you plaintiffs have to prove that these arms and these items that you are wanting to have protected and you want to have access to are not items that are exclusively or predominantly useful for military purposes. Now, I don't even, again, know what that means really, as far as useful, predominantly useful for. It's used, perhaps, right? You could say, is it predominantly used by a military? Well, the answer to that's obviously no. We're talking about semi-automatic only firearms, and setting aside, the handguns and the shotguns that the military doesn't even use. So they use some of the, sidearms, but it's funny that on the handgun situation, we in the Illinois case got their own experts to admit that handguns in the military are used for the same purpose they are in the civilian world, which is self-defense. So there goes that. They have no argument as far as I'm concerned for defending the handgun piece of it. But so here we are, sent back down to the trial court. The Seventh Circuit said you have to go back down to the trial court because you might, plaintiffs, be able to meet that burden of showing that these items are not military weapons, essentially. And so that's those are the undertaking we went through, and it was long and costly and time consuming, and ultimately, in my opinion, probably irrelevant. If the Supreme Court ever takes up this issue, unfortunately, I don't think that the Supreme Court will adhere to the Seventh Circuit's military weapons standard. And if it does, or says that that's a potential thing to consider, again, we had military experts. What we ended up doing in the trial court, once we were down, we had military experts, two United States Marine Corps gunners, former gunners, who are, for those folks who aren't familiar with the military, Marine gunners are essentially the weapons experts in the Marine Corps. They are the gentlemen who are relied upon to train folks on weapon systems, develop curriculum, training, tactics. So we had two Marine Corps gunners who were saying, nobody uses semi-automatic only rifles, at least infantrymen, right? I know that there's select, sniper rifles for there's 100 guys and the tens of thousands of people in the Marine Corps who have semi-automatic special purpose rifles, right? But we're talking about no infantryman is walking around with a semi-automatic only firearm, whether it's in the Marine Corps, the Army, Navy, wherever. Let alone not only just in the United States, but most likely the world. Okay. So we had these military experts opine on that, how these firearms are not utilized by the military. So our argument is, if they're not actually used by the military, how can they be most useful by the military? And they're just simply not.
It's funny that we talk about it in those terms, because you get down in the weeds on military versus, I guess that you might call it civilian. Okay. But at the end of the day, unless I'm missing something and you're immersed in this far deeper than I am. If you use the Bruin decision as your yardstick and your backstop at the same time, I'm not sure you can even make that distinction any longer. I don't think that you ever could, according to our founders, one way, shape, form, or the other. But now, when you're looking at decisions like Bruin and Rahimi and paying attention, you're saying, wait a minute, everything that you and I have known as Second Amendment advocates to be true all along is patently true and is now enshrined. So again, so recently enshrined. So let's get back to that. So are those decisions going to be gateways to help your cases, or the case that you're talking about in Illinois and all these others, ultimately get where they need to go? Or what are your thoughts on that?
Oh, are you referring to Bruin and Heller decisions?
Bruin Heller, yeah, certainly. And then that Rahimi case is a big deal. I'm watching things like Chevron deference evaporate and saying, okay, ATF, you're a regulatory body. You've outdriven your headlights. You can't do what you think that you can do. Dial it back. I'm watching all these things add up to being better times for the Second Amendment community in terms of what goes through the courts, because it's been pretty bleak for a while.
Yeah, potentially. I mean, it's our position that Heller alone commands that we win. You know, it's sort of it's circuit courts who are trying to manufacture ways around Heller and now Bruin that come to these conclusions that we shouldn't win. And so, I think a true reading of either Heller or Bruin means that we win. And so the problem here now is to get, the parents, if you will, the Supreme Court, to again remind circuit courts that no, again, that's not what we meant. We meant this. It's pretty, there are some portions of Bruin that are somewhat, not entirely clear, not as clear as we'd want them once you get into like the historical analysis and stuff like that. But that's not even where we're at in these cases. They're saying we fail at step one. We don't even get Second Amendment scrutiny. I mean, the notion that one of the most popular firearms in the country, the AR-15 platform rifle, it doesn't have Second Amendment protection when court after court has acknowledged, even if they uphold restrictions on them, they acknowledge that they're owned by the tens of millions. Mm-hmm. I mean, the notion that they don't even get protection is like strange, right? So
I saw the National Shooting Sports Foundation, NSSF, put out a some sort of article, or maybe it was a blog post in the last, I don't know, Sean, 4 maybe 5 days, that said that according to the industry experts and their tallies, and they're liaising with the people that build these for a living, they're saying that somewhere around 42 million AR-15s exist. Now, I'm not taking a swipe at where they're coming from or what they're doing, but I think the number, personally, I believe the number is far higher than that. But that's what they're saying. And that's a heck of a lot to say, well, it's this obscure thing. We're not really touching that many people. Let's not get too worried about it. I don't think we're disenfranchising very many of the 2A folks out there in the community. It's just not true. There are a ton of them.
Yeah, absolutely. And I think, again, fortunately and unfortunately, there's no way to count all of them because there's just not records kept. But you and I both know that there is a significant market for building your own rifles out of receivers. 80% when those were a thing. I guess they are again now. It depends on where you're at. I'm in California, remember, so I live in a different country. So we don't. Those things are illegal now here. But I agree. I think that there are, those are probably conservative numbers in the low tens of millions. So, but the bottom line is, the point we were making in the Illinois case, because of the pushback on the numbers, right? They try to throw, you don't know these numbers, and you're not counting for law enforcement ownership. You're not accounting for guns that went out of the country, and so on and so forth, right? Or multiple people owning. They're basically trying to say that, like, one guy owns 50 rifles, right? And so it's not millions of people. It's like a few thousand, gun nuts, right? But that's why in the Illinois case, when we had the opportunity to go back and address that about, okay, you're saying that we can't rely on just the numbers. Well, then let's broaden the scope on what we're looking at, not just look myopically at numbers. So we put on experts who are firearms trainers. They put on courses throughout the country, in Utah, in all over the country. I'm trying to recall what states they were all from. Illinois, but doing it throughout various states. And they explain that they have class after class filled with normal everyday folks who bring their own firearms to train, and they overwhelmingly bring AR-15 platform rifles with 30-round magazines to these trainings. And so the point of doing that, we had another former Remington executive to testify about the ubiquity, how popular these rifles were in the industry, particularly with Remington, who owned Bushmaster and DPMS and all that. That he could talk about those specific numbers, but like they can't necessarily talk about other companies or other folks' numbers, but they research competition, right? So they know who's in the space. They know they have competition. Yes. So yes. It's not like they're an anomaly, right? I mean, we got, my client, Piasaw Armory in Southern Illinois, is a little gun shop in Southern Illinois. And we showed how just that one little gun shop sold, hundreds and thousands of these firearms that are restricted over the years. And so if that one little shop is doing that, you extrapolate out, and they weren't, putting themselves out as like, we're the AR guys or whatever. I mean, you looked at their bound book, which got put in the record. It had every, your standard Glocks, your pump action shotguns, everything. So, the notion that, so the point I was trying to get to is that we wanted to put, we did put color on those numbers so that it's not just about looking at the number. If there's this many trainers and this many stores who are selling this stuff, and you look at the internet and you see the ubiquity of all the enormous marketplace, you look at Gun Digest, it's got page after page of these guns, of these parts, that's happening for a reason. If you just understand basic economics, these companies aren't just putting stuff out there just to like look cool. They want to make money, and they're not the ones driving the product. They are hearing from the customer, this is what we want. And this is, and of course, companies are going to put out a product that people want and that works effectively and that's safe, at least safe to use, right? Because there's a bunch of lawyers out there who will sue them if they don't work safe, right?
These companies aren't forcing their product into people's hands and then robbing them in compensation.
Yeah, exactly. And if you were going to, exactly. And if you were going to try to, manufacture a market, you probably wouldn't choose a rifle that's like $1,000 more or less, right? To its price point on average. That's far more expensive than a lot of other, traditional rifle platforms. That probably wouldn't be the smartest business decision to say, oh, we're going to risk like pushing this new market with a very expensive or relatively expensive, product.
Yeah, in a very litigious atmosphere. I'm going to pick a very tough place to occupy, and then fraught with all kinds of possible disaster, and that's what I want to go do for a business plan. Not very many people enter into that lightly, so I understand that. Now, is it okay if I switch gears for just 1 second?
It's your show. You can do whatever you want.
I'm not trying to trap you, but I do have a question. It's my understanding you say you're from California, yes?
Yes, sir. Born and raised.
Okay, so are you familiar with this Kamala gal? Do you know anything about her?
Huh? Who? No. Yeah. Yes. In my early career, when she was Attorney General for a bit, she was normally on the other side of the V on the lawsuits we filed, because when you challenge laws in California in federal court, you name the Attorney General as the defendant in their official capacity, because under the 11th Amendment, you can't sue a state, so you have to sue a representative of the state. It's kind of odd, but so yes, I've sued Kamala Harris in her official capacity a handful of times, and yes, I'm familiar with her doings in this state.
Okay. You don't have to answer if you don't want to, but is she the Daydream Johnny that I take her for?
Well, I mean, look, anybody who takes the Second Amendment and wants to defend the Second Amendment, takes their Second Amendment rights seriously, I don't see how they could support her unless there's some other issue that trumps, and pardon the pun, that is more important to that individual than firearm rights. And I'll be frank, I think she's bad on pretty much every issue. So, I'm biased, but specifically on firearms, I mean, it's funny. She's run for years as basically being hard on guns, pro gun control. She supported she says now she supports gun ownership in the Second Amendment. She supported a handgun ban in San Francisco. San Francisco banned the possession of handguns. I forget the year. As a matter of fact, I think that was even before I became a lawyer. We filed the firm I'm working with, Michelle and Associates, out of Long Beach, California. That's Michel. If anybody's curious, filed a lawsuit against San Francisco. And back in those days, that was before Heller. So there was no Second Amendment argument made. It was what's called a preemption argument. The argument was essentially a city can't ban the sale of firearms that the state expressly allows. And so they prevailed in the Fiscal case, Fiscal. But, Kamala Harris supported a ban on handgun ownership. So, and she also submitted or joined what's called an amicus brief. When you file in the appellate court or the Supreme Court, oftentimes what are called amicus briefs are filed from non-parties who have an interest in the case. So, sometimes attorneys general from other states will take a side on an issue, or, if, my client, the California Rifle and Pistol Association, they file amicus briefs in cases where they're not the plaintiff throughout the country. And Kamala Harris submitted an amicus brief in the Heller case, or joined one, that said that there is no individual right to own firearms under the Second Amendment. Hillary Clinton said the same thing, that the Heller decision was this awful ruling. But it's like, if you support the Second Amendment, you support an individual. What's left if you are anti-Heller? I mean, all Heller said was there's an individual right and you can't ban handguns. That's a pretty moderate, understanding of how things should be. And yet both of them were opposed to it. And they just talk out of both sides of their mouth. I think they have, like lots of politicians, they can convince themselves that it's okay to say I can have a gun as a politician, because I'm important. And I'm for the Second Amendment because some special people can have guns, but I'm okay banning it for the vast majority of people, and then making exceptions for, my politically favored groups.
It's funny that you mentioned that. I wasn't going to touch on this, but you walked right into something that I often mention to guests and that kind of thing. And I guess it isn't anything that you and I have discussed, so I'm curious what your thoughts are. Let me make a couple statements and maybe you can respond. It seems to me, Sean, that it's a really interesting opponent that we have, because when you boil down these folks' mindset, and I can never truly know what they're thinking about, but it appears obvious that it isn't something that they want to take from you to have themselves. That's what's really interesting about the Second Amendment. They don't want to come take your car so that they can have it. They don't want to take your house. They don't want to take your tax. They don't want to take your money so they can have it and use it for themselves. But this is something they simply don't want you to have. So it really isn't about the gun. It really isn't about the arm, whatever that may be, whether you say with a hand grenade gun or a bow and arrow, whatever it may be. What I'm saying is it's about that they don't want you to have the means for some sort of defense. They don't want you to have it. So if you think about that mindset, what they're really saying is, I'm not saying that I want it. I'm saying that I don't want you to have it in any way, shape, or form. And that leads down a very narrow road, in my opinion, as to what those outcomes are that they're hoping for or hoping to avoid. I mean, what do you think of that?
Yeah, no, I think it's obvious that it's about control. Gun control is not about the gun; it's about control ultimately, right? I mean, if they were serious about it, and I think this came up in the vice presidential debate, if you were serious about gun crime, then you would prosecute and bring the hammer on people who commit gun crime. And I'm not talking about gun crime like possession of an invented assault weapon. I'm talking about, shooting an assault weapon at somebody unjustifiably, right? So you have these same people who are saying, oh, well, you all can't have guns. But the guy who's putting a gun in somebody's face in a mini mart, right, and endangering everybody's life, he gets out on no cash bail, right? So I say put that guy in prison, right, and make his bail as high as possible, and let me keep my gun in case he puts it in my face, right? But yeah. So they're not serious about it, about that it's for protection. It's not about protection. It's about control. And the firearm is the quintessential symbol, both symbol and practical tool of a free person, right? Like you cannot get any more. I have the power in my hand to defend myself than that, right? As far as freedom, and the car is the next one, right? After a firearm is the car. And I don't want to go too far down that road, pardon the pun, but again, here in California, they're essentially banning gasoline vehicles and making them all electric. Why? Okay, we've all seen how electric vehicles are essentially lined up during bad times because nobody can get a charge, and those are more easily controllable than a combustion engine. So it's certainly not about the people's welfare. It's about the politicians' power.
Without a doubt. It's a pretty bothersome thing to think through. And it's a little disheartening on some levels, but we fight the good fight. So we spoke about it just before we started the recording. So, and you and I had just a couple of quick minutes to familiarize ourselves. Granted, you and I have worked together. Thank you. In full disclosure, Sean represented me for about 6 seconds that he whipped up something and took care of me personally. Thank you again for that, Sean. I was amazed at how quickly and well that went after all my worry. So thank you for that. So we do have a small relationship there, but we talked briefly about what comes next. Okay. So you're handling some suits, you're putting in the time and the effort. Thank you for that, because I recognize that when you do the work that you're doing, that many other people benefit. And so that can't be understated. Thank you sincerely for that, Sean, very much. So what do we do now? Taking your lead, taking other people's leads. What do we do as a group in order to make a significant impact moving forward?
Sure. So first off, you don't have to thank me. I mean, I get paid, not as well as I'd like to be, but I get paid to do what I do. I am a true believer, if obviously you couldn't tell, and I do it willingly and enjoyably. Although, again, I wish we didn't have to have this fight, but because the fight exists, I'm happy to do it. So no need to thank me. Who deserves the thanks are the groups that are able to fund these types of lawsuits. And in Illinois, that includes FFL Illinois, Gun Save Life, Gun Owners of America. And here in California, it's the California Rifle and Pistol Association, Gun Owners of California. So, those folks deserve the thanks. They facilitate this. Without them, there wouldn't be any pushback. But the reality is, in my opinion, right, once we're in courts, we're already kind of losing, okay, because of how much it costs, and because we're on the attack, but we're also, that's a defensive attack, right? It's out of necessity.
Sometimes these risks are huge. I get that. I do.
Yeah. And you know, but we would be far better off spending these resources instead of on lawyers like me. And when I say we, the firearm community, on getting back to what the firearm organizations were originally intended to be. And that is spreading education and training on firearms, which is kind of hilarious when you hear these politicians chastise the NRA or the CRPA or Gun Owners of America, all these groups as, oh, once upon a time, they were a training organization and that was good. Well, yeah, if you let them get back to doing that and dedicating their resources to that instead of having to defend themselves, you know, we would all agree. We would love to be in that position, right?
Yeah.
But unfortunately, you know, we're here. And so I say all that with, you know, going back to the Kamala Harris point, you know, elections have consequences. And these folks who pass these gun control laws are going to continue to do so if there's no political consequences for them. And they're, you know, that's the only way to stop it. You know, the courts may or may not come to our rescue. I mean, here we are. Yeah. I'm involved in a case in California that's challenging California's so-called assault weapon ban. That's pretty much identical to Illinois, although not as crazy. Like I said, California only bans centerfire rifles. And it's been going on for 7.5 years. Okay. 7.5 years we've been in courts, up and down. I've gone to the Ninth Circuit, back down, back up. Here we are again. And that's that's why I say we're pretty much already losing once we're in the courts, because there's just justice delayed is justice denied. And sure, you know, you got to think long term. Hopefully we ultimately eventually get to a point where the courts have made clear that it's not going to tolerate these sorts of things. But there's no way this issue is going away. The politicians who are anti-gun will continue, even if they lose on this assault weapon issue, excuse me, or large capacity magazine issue, they will pass additional things to test the boundaries, to force the circuit court's hands, to force the Supreme Court's hands. You know, here in California, we have ammunition registration.
Yeah.
I mean, that'll be, you know, the next thing if they can't do this. They will always try to find some, and that's been happening in California now for years. They've already banned everything that's like meaningful, right? So now they're kind of just finding these little weird angles to say, like, oh, let's make this more expensive, or let's make this more difficult, even though they know it does absolutely nothing. It just gets their name on a bill to say that they're tough on guns, right?
Well, they've kinked the garden hose out there. I mean, I don't think very many listeners here may know this, but you're limited to how many firearms you can buy in a given year. What is it? One firearm a month, Sean? Is that right?
Believe it or not, that was a law that just got struck down here in California. So
really,
yeah. Although again, you know, it got struck down at the trial court level. We'll see what happens, you know, as it moves on up. But you know, another thing about elections having consequences is, once upon a time when I first started doing this work in California, the Ninth Circuit was almost a foregone conclusion you were going to lose. I mean, if you drew a pro-gun panel, it was, I think I drew one once in a case, and then it got overturned en banc. Yeah. And en banc, if people don't know, in the Ninth Circuit, you are assigned a 3-judge panel. Yeah. They make a decision. And then if somebody requests it or the court requests it, there can be what's called an en banc panel. That's 11 judges in the Ninth Circuit. Yeah. And we got, you know, we prevailed actually in a case before, and early on in my career, and then it got overturned by an en banc panel. But since then, speaking of elections have consequences, you know, President Trump put in a lot of good judges in the Ninth Circuit. And so the math is not as bad as it was previously. It was impossible to draw a pro-gun en banc panel before President Trump.
Yeah.
Impossible. Now it's still, the math is against us somewhat, but it is possible for an en banc panel to and if that's the case, I mean, that's Ninth Circuit precedent. It would be hard math. It's unlikely to happen, but it's possible. And it's very possible to have a lot of pro-gun 3-judge panels. We've had them. There's been several victories in the Ninth Circuit on these cases. They just get taken away by an en banc panel almost every time, which says a lot. I would like to invite everybody to read Judge Van Dyke out of the Ninth Circuit's commentaries on his fellow judges. And I'm going to be careful because I don't want to endorse them necessarily. I just think it's worth a read to understand how things are working in a circuit where every single pro Second Amendment opinion to come out of a 3-judge panel in the Ninth Circuit has been taken en banc. Not a single zero opinion that has come out anti-Second Amendment has been taken en banc. And I think that speaks for itself. En banc is should be a rare thing.
Yeah. It's kind of funny how you can be claim to be a judge or a justice and then look at the founding documents that outline justice and categorically deny them.
Yeah, it's people, I think, are still holding on to the notion that the Heller court got it wrong. These judges, and so they're essentially, the Seventh Circuit opinion for our case in Illinois, the Seventh Circuit opinion in the Bevis case, Bevis, is essentially saying to now deceased Justice Scalia, like, I think you were wrong, and kind of mocking the opinion and kind of mocking how the Supreme Court has handled the Second Amendment. So yeah, I mean, there are judges who disagree, and that's fine to a certain extent, but on something as black and white as like you have an individual right to this, that ship has sailed.
Yeah,
or at least, well, as long as we still have 9 justices on the Supreme Court.
Yeah, well, we'll see. I don't know. All these things are subject to restructure if elections, as you said, elections have consequences if they don't go the right way. So my suggestion is the same one that you've mentioned, is that when we go, first of all, we have to vote. We absolutely have to. There's no way that you can sit back and take an advocacy position and then not advocate through a vote. So what really needs to happen is we need to make sure that our vote, or our action rather, becomes a force multiplier for a hoped outcome. So what that means is, if you're going to go vote, take one of your buddies with you, take a neighbor with you, make sure your spouse goes. I know a lot of people who are going to go vote or have, and they don't even bother taking their spouse. They're political themselves, whether it's a man or woman, doesn't matter. And they won't take their spouse. Oh, I don't really get involved in that stuff. No, you've got to be involved in that stuff. You can't sit back and say, well, I want this outcome, but I'm not willing to check a little box for it. So take somebody with you. If you've got a sedan, what that really means is you've got 4 potential voters there that should be going to the polls that day. Fill the seats, Okay, absolutely. Fine. If it's a motorcycle, maybe you only take 1 with you. But if it's a car, you got to take more people, and you can, so you should.
Absolutely. I mean, you don't have any excuse. You have no right, in my opinion, to complain about any of this if you're not voting. And at this point, I just can't see there being anything more important than voting and taking a friend, a family member. Going beyond that, I think talking to neighbors, getting people engaged. Ideally, everybody would bring 10 people or convince 10 people to go to the polls. Think of family members and friends in states where the difference might matter. Arizona, Georgia, Pennsylvania, Wyoming. I don't know, Wyoming. Wisconsin. I don't think Wyoming's up for play. You know,
you never know, but yeah.
Well, yeah, you know, Iowa, I think is probably safe, but it's not. You know, you can't assume that, and I think that's a problem. Is a lot of people, you know, I hear all these folks, you know, saying that they're, you know, oh, I'm pro-gun and I'm pro-Trump and this and that, and then okay, did you vote? No. Okay, well, what's the problem? You know, we're not. Nobody's asking you to do what our grandpas did and like, you know, charge Nazi machine gun nests, right, at 17 years old, 18 years old, and you know, never see your family or your homeland again. Simply asking you to like go vote and hopefully convince a few folks who you think should vote to go vote with you.
Yeah, I honestly, I wish I could remember the numbers. They were absolutely huge. But I think it was something coming out of Pennsylvania on how many million hunters there were in Pennsylvania. I want to say that Pennsylvania sounds like 12 million people. Does that sound right? Maybe. And that 2 million identified themselves as hunters. And what was it? Over half don't vote. I don't know how you can justify that. I mean, it was, I think that those numbers are right. It was, if not, we should look them up. But the truth of the matter is it was disappointing. I could not believe that few people out of something that requires them to use arms. I don't think they're going out into the forest, sitting in a deer stand and staring at a deer until it falls over. I think they're probably using some method to harvest the deer. So they have a vested interest in the Second Amendment in arms. They do.
Sure.
So, anyway. Okay.
Absolutely.
So, Sean, thank you for your time today. What do we need to cover real quick that we haven't? Have we got everybody kind of up to speed on what's going on next door? Consequences for elections. I mean, what are your thoughts here?
Yeah, so I think we've covered that. But going back to the case, just so everybody's aware, you know, you can follow it online. I don't do the social media stuff, so I apologize. But if you look up the case, there's plenty of stuff online, plenty of people covering it. But we had a trial in Illinois 2 weeks ago, concluded 4-day trial with live witnesses, expert witnesses. We are now in the process of briefing. The case did not close post-trial. We will be submitting our final brief here in about 2 weeks. I believe it's the 19th that it's due. So we will be submitting our brief, and then the court will weigh in. I feel very positive about our chances to prevail at the trial court level. But of course, that's not the end of the case. So yeah. I suspect we will have a decision, hopefully in our favor, maybe by the end of the year.
Okay.
And then, of course, the state will appeal that. So probably early next year, early 2025, we'll be up arguing or briefing the case before the Seventh Circuit. And I honestly am not familiar with the timelines of the Seventh Circuit. I believe it's much quicker, fortunately for us, than the Ninth Circuit. So that's a timeline. I think, you know, mid next year we should be have an idea of what's going on with this case in the Seventh Circuit. But in the meantime, I mean, there are other cases that are further along than this one. There's one in the Fourth Circuit, I believe, and also the First. I mean, they're already sort of knocking on SCOTUS's door. So this case may end up just being stayed again, like my California case, and we'll just wait to see what the Supreme Court says. Which, you know, frankly, it would be kind of a shame to have done all this work and then we just have to take back seat while something gets handled. But if you know, whenever, however, the Supreme Court gets this issue in front of it on what firearms can be banned as so-called assault weapons and what capacity magazines, we want it. You know, regardless, I don't really care. I don't want glory or my name or whatever. I just want this issue addressed. It needs to be. It's you know, crazy. Every court to have heard it is just, not every court, but you know, a lot of them. It's just they need some direction,
Yeah.
some firm direction. Yeah. So yeah, people, I think the big takeaway is support the folks who are making these fights possible. Look into who the plaintiffs are, what groups are involved as plaintiffs in these cases. My clients in Illinois, FFL Illinois, Gun Owners of America, Gun Save Life, those entities, and then here in California, the California Rifle and Pistol Association. Support those folks, whether it's monetarily or subscribing to their stuff and pushing it out to other folks, sharing it with folks who live in those areas, Illinois or California, or just spreading the word. And then, of course, voting.
Okay. We're going to do that. So when people type something in their search engines to go hone in on this specific case, what do you want them to type in?
So let's see here.
So I don't want to cover that. And then you said something about what was the judge's remarks in California. What was that? You need to list those things off real quick so people can get that.
What was I'm sorry, I missed that, Michael. What was the other one?
You were talking about Judge Drexel or Dennis or something like that out there, and you mentioned what he said. Go read that. And I didn't commit that to memory. So we need that. And then what people need to search for to read about your case.
Yeah, Judge Van Dyke, VANDYKE. You can follow FFL Illinois, Gun Owners of America on all their social media. They're putting stuff out there.
Okay.
So I think that's the main case. Even so, like I was telling you, there's 4 groups of plaintiffs, so there's a ton of different plaintiffs involved. Those are my clients, but there is the overarching group is it's being called by the court the Barnett v. Raoul, RAOUL, is the case to search for in Illinois.
Okay. All right. Sean, thank you very much. I appreciate you taking the time. I know that your time among many people's is valuable. I really appreciate it. Thank you again for your work. Thank you for your willingness to come on to help us with some context here. It takes us a long ways because the truth of the matter is without the context, I'm not sure that it matters much. These things go in one ear and out the other. And so we really need some help with a deep dive and some red meat to chew on. So thank you very much for that.
My pleasure, Michael. Anytime.
Thank you.
Have a good one.